Hello, we're the 365 Review channel, and dedicated to making reviews and media summaries on specific topics we're familiar with, aim to offer viewers with different insight from multiple perspectives. In this video, we focus on copyright, one type of intellectual property. Intellectual property or IP refers to the property category related to the intangible creations of the human intellect minds. There are many types of intellectual property and they have become inseparable from our daily life. In this video, we'll summarize the concepts and their symbols of three most important intellectual property, namely the copyright, public domain, and Creative Commons. Hope to provide useful information for you and help you to effectively protect yourself and correctly use them. This picture best describes the freedom you can enjoy using each of the three intellectual property, from the top, the most free category, to the bottom, the most restricted category. The Creative Commons is in between, is generally free but there are conditions attached. We'll discuss each of them in separate video. This video focuses on copyright. Copyright is very important for human society. Most countries have enacted the copyright law. There are two fundamental purposes in copyright laws. One is to protect original works of the authorship and ownership. Two is to promote the progress of useful arts and science related to the copyright. The two purposes look seemingly contradictory each other, but they are not, when we think deep. Creative Commons or CC is an American non-profit organization devoted to expanding the range of creative works available for others to build upon legally and to share. The organization has released several copyright licenses, known as Creative Commons licenses, free of charge to the public. These licenses allow creators to communicate which rights they reserve and which rights they waive for the benefit of recipients or other creators. The public domain consists of all the creative works to which no exclusive intellectual property rights apply. Those rights may have expired, been forfeited, expressly waived, or may be inapplicable. Here are the enlarged symbols of copyright. The copyright symbol is letter C in the circle. Early copyright symbol is letter P in the circle. The P stands for phonogram, related to music copyright at earlier time. Even though some copyright provides free access, almost all of the copyright materials are protected by laws. The respective copyright holders retain rights for reproduction, redistribution and reuse. Users are directly and solely responsible for compliance with copyright restrictions and are expected to adhere to the terms and conditions defined by the copyright holder. Transmission, reproduction, or reuse of protected material, beyond that allowed by the fair use principles of the copyright laws, requires the written permission of the copyright owners. A copyright-related concept is copyleft. Yes, it says left. See the different directions the C letter points to. Copyleft is a licensing scheme in which an author surrenders some, but not all rights under the law. So the copyleft license can't be treated as public domain. Pay close attention to the attached lines and contexts when you choose to use a copyleft license. Copyleft allows license owners to impose some restrictions on those who want to engage in activities that would more usually be reserved by the copyright holder. Under copyleft, derived works may be produced provided they are released under the compatible copyleft scheme. Here is another concept in intellectual property, the trademark, which frequently goes in parallel with copyright in many situations. A trademark is a type of intellectual property consisting of a recognizable sign, design, or expression which identifies products or services of a particular source from those of others. The trademark symbol is letter R in the cycle. The cycled R symbol is reserved for trademarks registered with the appropriate government agency. The TM symbol is used in connection with an unregistered mark. It signifies a trademark application has been filed and is pending with the USPTO. The use of this mark is not a guarantee that the goods will receive a registered trademark. A TM-related symbol is SM symbol, which is for service mark. This is used similarly to the TM symbol. However, the service mark SM identifies and distinguishes the source of a service rather than goods. Here is another copyright-related concept, The patent. A patent is an exclusive right granted for an invention, which is a product or a process that provides, in general, a new way of doing something, or offers a new technical solution to a problem. To get a patent, technical information about the invention must be disclosed to the public in a patent application. There is no defined symbol for patent. In a situation that requires an image or symbol to signify a patent, the image of the USPTO seal from an issued patent is often used. After the adoption of America Invents Act, it requires the patentee to affix the word patent or PAT in short on the product followed by a patent number or internet address. Doing so is important, especially in patent infringement lawsuits. Patent pending or patent applied for can be displayed on products, but these do not stand for a patent legal status, more frequently used by people as a warning sentence. Some facts about current U.S. patent law. In 2011, the former President Obama signed the American Invents Act. This new bill amends federal patent law to define the effective filing date of a claimed invention as the actual filing date of the patent, also known as first inventor to file, replacing the traditional first to invent system. People have different opinions on the new patent law. Obviously, the new patent brings the U.S. in line with most of the international community, simplifies international relations with regards to patent law and enforcement. On the other hand, the change benefits larger companies who have the lawyers and money to file many patent applications, and they can obtain the patent content legally or illegally even they do not have the invention. Sadly, from our own view, we would not consider filing any new patents if we aren't sure we can get it. The reason's very simple: the rules are not in favor of small inventors. You know, there are plenty of smartasses on the street. Some legal scholars think such a change would require a constitutional amendment and the new patent law may not solve the problems. In U.S., copyright covers both published and unpublished works. Covering of unpublished works is a huge protection for individual and small business. Copyrights are different from patents and trademarks in that a copyright is protected the moment it is created and fixed in a tangible form. This means that it is perceptible either directly or perceptible with the aid of a machine or a device. You need some sorts of proof or evidence of your creative works. Copyright has developed into a concept that has a significant effect on nearly every modern industry, including not just literary work, but also forms of creative work such as sound recordings, films, photographs, software, and architecture. It is worth mentioning that registration is not required for copyright work as long as you can prove it later. But official registration does provide legal advantages and is necessary before filing an infringement lawsuit. The Fair Use Guidelines are available from the Copyright Office at the Library of Congress. The U.S. Copyright Act sets the doctrine of fair use. Under the fair use provisions, brief excerpts of copyright material may, under certain circumstances, be quoted verbatim for purposes such as criticism, news reporting, teaching, and research, without the need for permission from or payment to the copyright holder. In its most general sense, a fair use is any copying of copyrighted material done for a limited and transformative purpose, such as to comment upon, criticize, or parody a copyrighted work. For example, using a segment from a news broadcast in a documentary in which the broadcast is discussed, would be considered a fair use. Uses of copyright materials for purposes such as criticism, comment, news reporting, teaching, scholarship, or research, are generally not considered as an infringement of copyright. Its well-known fair use has long been a legal excuse for media and news reporting. But this is changing and become difficulty. Here is a court case. New Jersey Media Group sued New York-based Fox News for copyright infringement of their 9/11 photographs. Fox News argued that its uses of the photos were the visually altered, significantly cropped and low-resolution versions of the photos, and their use of the photos was for the purposes of news reporting or commentary, which should fall under the fair use provisions of the copyright law. Surprisingly, The court skipped the debate on if Fox News use was fair use, and the court focused heavily on analyzing the 4 statutory factors for assessing whether a particular use qualifies as fair. The court found that Fox News use would likely encourage other news media outlets not to seek licensing fees, thereby damaging the primary market for the photograph. This court opinion is not in favor of Fox News' arguments. Fox News was essentially likely to lose the case. Both sides settled the copyright dispute on a confidential deal later. This case will have some future impact on the excuse of fair use. The European Union new online digital copyright laws will make fair use even harder. The concerns are that less information and fewer resources would be available through search engines. Under the new derivatives, user upload services are considered as copyright-covered materials and need a license. Article 11 and Article 13 of the EU derivatives are much criticized as upload filter and link tax. The directive has generally been supported by newspapers, publishers, and media groups, but opposed by major tech companies and internet users, as well as human rights advocates. Disney's Mickey Mouse is an interesting case in intellectual property and has been the center of a variety of controversies regarding copyright. Mickey Mouse is not copyrighted because characters is not copyrightable. Rather, the 1928 animated short film, Steamboat Willie, is copyrighted. Mickey Mouse, as a character in the movie Steamboat Willie, is also covered under the copyrighted work. Steamboat Willie is especially notable for being the first Disney cartoon with synchronized sound and fully post-produced soundtrack. Steamboat Willie is set to enter the public domain on January 1, 2024. This technically means that the Steamboat Willie version of the Mickey Mouse character will no longer have copyright protection starting in 2024, although later iterations of the character of Mickey Mouse would most likely still be copyright protected, lots depending on details of their use under local laws. The trick is this: Mickey Mouse is still a trademark of the Walt Disney Company, and trademarks never expire. However, it is part of established U.S. trademark law that you cannot use trademark rights to prevent people from advertising items in the public domain. Let's wait and see what game Mickey could play this time. Anyway, Mickey is cute and can always give people surprise. Some thoughts about copyright. Just be careful with using copyrighted materials. Hope you enjoy the video. If you do, please consider liking it, sharing it and subscribing to our channel to view our video library. To join us, click the subscribe button or our YouTube webpage link.